All right, ladies and gentlemen, welcome to Senate Judiciary. Let's go ahead and get going. Ms. Ogden, if you will, call the roll for me.
Senator Albritton? Senator Bell? Senator Carnley? Senator Coleman-Madison? Senator Elliott? Senator Figures? Senator Givan? Senator Orr? Senator Singleton? Senator Smitherman? Senator Stutz? Senator Weaver? Senator Barfoot?
Here.
And we have a quorum.
All right, thank you so much. We're going to jump a little bit out of order. Representative Almond's got to be somewhere at 9, and we've got a little bit of a late start. Pretty voluminous bill. If you could, Representative Almond, come up and talk to us about HB 200. I don't remember it. We may have seen a version of it last year, but good morning.
Good morning. Thank you for letting me go first. I appreciate that. This is HB 200, and there's a Senate companion bill also. This is an update to the Alabama Business and Nonprofit Code. Most of you know that in 2013, the Alabama Law Institute undertook to revise this in whole. And they keep a standing committee that looks at this every year and makes recommended updates to it. So that's really all this is, even though it's a lot of pages. Primarily, it's technical updates. There are some substantive changes, and with your permission, I'd like to highlight one that's actually my favorite.
Sure.
It's under the LLC portion of the bill. If this is adopted going forward in your LLC agreement or operating agreement, you will be able to designate who you want your interest transferred to upon death, and that will be in lieu of having to probate your estate to transfer your interest for that particular reason. So I think it's an excellent time and money saver. Yes, sir. I'm sorry. I'm not supposed to call on you.
That's all right.
I'm not in charge.
You're a little bit ahead of me, but I'm gonna recognize Senator Smitherman.
Thank you.
I'm not surprised. You know, I'm on a few committees with you. You'll take charge first. Nothing wrong with that. I want to ask sort of a humorous question. Then I want to make a statement right quick. How many pages is that bill?
Well, a lot.
How many?
A lot. 140, 50, something. 154.
That's just like a Christmas present to me. but on a more serious note, Mr. Chairman, I want to move for favor report because I understand what you're saying and you're doing. You know, I knock on wood. I thank the body when I say it this way. But you know, I'm on the board with the Alabama Law Institute, so I get a chance to go out meetings and see what they're trying to get done in all these different areas. Mm-hmm. And I'll just say this, I know most of my colleagues know, but this is a panel of probably, 25 or 30 lawyers all over the whole state that look at these situations from every angle and from every point before they make the recommendations to us. So I just want to move for favorable report.
You got a motion for favorable. I'll second that. Any discussion, further discussion on the bill?
There is an amendment. There is an
amendment. Okay, let's go back. Who's got the amendment? Who's going to offer that amendment? All right. In lieu of, you got a copy of that amendment, Holly? Okay. Let's keep talking. Tell us a little bit more about your bill real quick.
Okay.
I do have a question on the LLC
yes.
Portion of that equation. You know, I'm an attorney. We have an LLC. I think that would probably be different from my standpoint. I don't know that I can give a non-lawyer the interest in my LLC. Is that correct, or do you?
For your law firm?
For my law firm.
Oh, yes. I think that's, well, that's probably correct, yes. I mean, because they would need the necessary license to carry out the purpose of the LLC.
Right, and without, it would be my understanding, this is not a trick question, because as I understand it, a non-lawyer could not have an interest in an LLC that sole business was to practice law. Lawyers, any questions?
I wonder if you could transfer your membership interest, but they wouldn't be able to carry on the business. I don't know the answer to that. It's a good question.
All right, in lieu of time, let's go ahead. We've got a first and a second. There's a possibility of getting that amendment on the floor. I don't want to hold up progress this morning, so we've got a first and second. Any other discussion? The bill is originally presented to you today. Senator Figures?
I would just suggest that we maybe hold it over or call it back up when Senator Givan gets here with the amendment.
Okay.
And then add the amendment.
Well, there he is, right on time.
Great.
Senator Givan, I understand you have an amendment.
I do. We have a request from some learned attorneys. I'm not sure I see the distinction, but basically on page 46 and on page 143, it is to keep the status quo of the current code. And so the language that is in the amendment is simply going back to what the current code is, and this is dealing with derivative actions. Derivative actions are on a shareholder is basically saying the corporation needs to take a certain action, they won't do it. And they were worried, lawyers who are in the business litigation world were worried about the nature of this, that this was changing current law. So I would offer this amendment.
It's my understanding this is a friendly amendment.
I'll second.
You got a first by Senator Givan, second by Senator Smitherman. Any discussion on the amendment as described by Senator Givan? Hearing none, Ms. Ogden, if you'll call the roll on the amendment.
Senator Albritton? Aye. Senator Bell? Senator Cornley? Aye. Senator Coleman Madison? Aye. Senator Elliott? Aye. Senator Figures? Aye. Senator Givan?
Aye.
Senator Orr? Senator Singleton? Aye. Senator Smitherman?
Aye.
Senator Stutz? Aye. Senator Weaver? Senator Barfoot?
Aye. All right, the amendment's given favorable. Any further discussion on the bill as amended?
So move.
All right, we've got a motion for a first reiterated by Senator Smitherman. Second, who had the second on that? Senator Albritton is the second on the bill as amended. Any opposition using previous roll? Hearing none, bill's given favorable report as amended. Thank you so much.
Thank you very much.
Is Representative Brown here? Oh, come on up. We're going to be doing, this is going to be HB2. Representative Brown, if you will, tell us about your bill.
Thank you, Mr. Chairman. Members, I have House Bill 2, and this has actually been the third year we've been in here. It got on the calendar late last day of the session, 2 years in a row. So what this does is right now the age of medical consent in Alabama is 14, and this just strictly deals with vaccinations and just provides that any vaccination for a minor, it has to have parental consent.
Senator Smitherman.
Thank you. I mean, what's the significance of of changing from 14 that, when the law was established, there was a reason for it to be in 14. And if you know that, share that with us. And why are we seeing that it's necessary to change it about the vaccine? And I'm just being kind of honest with
Sure.
frank with you.
Sure.
Is that I know my concern is that we may be, I'm not saying you personally, but this issue, we may be putting politics above safety and life. All this rhetoric about not taking vaccines and they ain't good, this, that, and the other, and we are reacting to that to tell something that has been that medical. It's some rationale why we got to 14 now because of possibly political stuff. Now we got to change this because all this uproar about vaccines. And so I'm just concerned because I'm concerned with the safety and welfare of the children over politics.
Sure.
So you want to share, Kenny?
Sure. Yeah, well, my understanding is if you go back and you look at why it's 14 is it came about after Roe versus Wade in the early 70s. And so we're one of the only states.
And what does that mean? I mean, why did it come after Roe versus Wade? That's what I'm asking. Not just what happened, but what was the rationale behind it coming after Roe versus Wade? If you know?
I don't know. My thought would be that it was a reaction to that.
How would it be the Roe versus Wade? That dealing with going to school. I mean, just integrating schools, isn't it?
No, Roe versus Wade was the abortion.
Oh, the abortion did it because of abortion?
Yeah, well, that's my understanding. In these early 70s, it matches up. But this
So-
has nothing to do with the overall,
So the 14-year-old could say that they want to go get an abortion?
well,
You know, you said it came out the Roe versus Wade, so
came after Roe versus Wade. So
so they're not connected then.
I don't know that. I'm just saying that that's my understanding from people that were around in the early 70s is that it was a reaction to Roe versus Wade.
Oh, that's street talk.
Street talk, exactly.
Street talk.
Exactly. And this has nothing to do with overall age of medical consent. This strictly deals with vaccinations. And
That's
the
what I
reason-
mean, but that's consent, though, isn't it?
Well,
Now
the
that 14-year-old that we are saying exists now. I'm just asking. I'm not back and forth
No,
with
no,
you.
I'm not.
But we are saying that they, up until you bringing this bill, at 14 they can give the consent, and so I'm trying to ask what medically or what in that regard or drives us to where now we need to say, well, on vaccines you can't do it at 14. You understand where I'm trying to come from?
I do understand what you're saying. And my thought on it, and the reason I brought this legislation was twofold. One, a 14-year-old can't buy a beer. They can't drive. They can't even have a learner's permit. They can't go see an R-rated movie, but yet they're making a medical decision on their own whether to receive some vaccination or not. As long as they live under a parent's roof, the parent should be the one that's responsible for their medical care. That's what it gets down to.
Yeah, but then that's being selective because we're saying 14, they can do all the other stuff, but on the parent, they 14, that parent should do that. I mean, either the parent should do it all, or we should stick with what's there. I mean, because that's carving out a little piece and say, well, parents, you got this right, but kids, you still got this right. That's what we're saying here, and yet. You were saying the things that you mentioned, examples, I know you could probably give some better ones. I got you on the spot here. But the things that you're giving examples, it's not life or death. Vaccines, you look at these measles. I'm just forget all this other stuff everybody complain about. If you don't get vaccinated for measles, you going to get zapped in this country. That's what getting ready to happen. So you understand the concept I'm asking about now. I'm just trying to say that.
And I'm not saying they can't get a vaccination. I'm not saying anything about vaccinations. I'm just saying from a parental rights standpoint, the parent, when it comes to that, should be the final arbitrator of that decision of a child's health. And imagine this scenario. A child goes down, let's say, to a pharmacy, wherever, and gets a vaccination at 14, 15, 16. Maybe that child has some type of allergy, some type of reaction to that vaccination. It could be deadly. That parent has no idea that they went and did that.
Well, but they will be doing it right now within the perimeter of the law. And now think about what that example you just gave. I'm just giving a scenario, what you said. So we're saying that, quote, when our leading drugstores where you can go in and get a vaccination, we saying that them people going to be negligent. You don't want to say that. That's what you just said. You said if he take it, and I know they go through a protocol. You just can't walk off the street, stick your arm in there, and they pop a needle in it. It's got to be a certain protocol that they have to. Yeah, it's a protocol. And so that ain't going to happen. What you just said, if they go to a established place, like you just said, walk in the drugstore, whatever, we got them up there. I've seen them. I've been in there to get my prescription and see what they do with the people that was getting those free vaccines and things. And they don't do that. So, that concerns me. And then we're saying we got some bill that's coming up, and I'm going to be through, Mr. Chairman. We got this bill that's coming up, and I forgot what it is, that we talking about zapping them at 16. I think I'm right, ain't I, Mr. Chairman? We got some bill that says that, that somebody's out there now, because I'm in you, that's what I'm asking you, that says that if you do this or do this, then you can get either the death penalty or you can get something like that. But yeah, we tell them over here, you can't, we're going to let you do vaccines, but over here, do that, but over here, this one you can't do. That's not consistent with what we are saying, because if those things that you said of values, which I don't question your values, is that they should be values all the way through the process, not selectively for what is perceived to be politics. You see what I'm saying about vaccines? You know, now I ain't gonna get into where it is and all that stuff, but I mean that's the realities. I don't want to play politics with these children, and so I want you to understand where I was coming from. I don't want to do that.
Sure,
Thank,
Senator.
thank you, Senator Smitham. Senator Figures?
Thank you, Mr. Chairman. I believe that the bill that Senator Stutz is carrying in terms of access to medical care would take care of this situation. Senator Stutz might want to comment on that.
Mr. Chairman,
You go right ahead, Senator.
yes, I have a bill about medical consent, raising for all medical consent to 18. Senator Givan is also involved in that. So
We're trying to change it to 16.
So this is just a carve out of medical consent and making it just for vaccines.
I understand. Thank you. All right, Senator Singleton, and then I'll entertain a motion.
Based on Roe versus Wade happened in 1973. Between 1973 and today, based on the scenario that you gave us, how many kids has been affected like this being 14?
Oh, well, I don't know, Senator. I would estimate millions. I do know that,
That have been affected?
well, I've been impacted by
Been affected?
bad vaccines or,
That there has been a problem in their family, had to sue or something based on negligence that someone gave them?
well, essentially you can't sue. Who are you going to sue? The drug manufacturer? You can't sue the drug manufacturer.
They sue the store, the doctor, if there's something happening.
No, there are thousands.
I'm asking, has there been a problem up until this day?
Yes, there's thousands of adverse reactions from adults and children and different types of vaccines. I personally, I know that for a fact. I personally, when we were deploying in my National Guard unit, we got smallpox vaccines. It was a bad batch of vaccines. Several people got sick. One female soldier fell down the bleachers. We had to take her to the medevac.
Minor, a person 14 years of age, maybe they're
Not that day, but you know.
All right, Senator Givan,
So, two things.
and then we're going. Then I'm going to entertain a motion. We kind of beat this horse long enough.
This doesn't really tie to what Senator Singleton was saying, but what was apparent when he said that date, and I may be wrong on memory, but I'm thinking this bill came in 1970, 71, or 72. I mean, it is what it is.
Right.
We'll look at that. I didn't know the year of, I kind of was under the same assumption, but it sounds like that assumption is off.
It could
We
be,
can figure
sir.
that
Yeah.
out and put that to bed. But if we pass either, I can't remember the bill numbers, but this may be moot if we pass the other bill, but we hadn't passed the other bill yet. So at this time, I'd move favorable report.
Got a motion for favorable by Senator Givan, second by Senator Orr. Ms. Ogden, if you'll call the roll.
Senator Albritton? Senator Bell? Senator Carnley? Senator Coleman Madison? Senator Elliott? Senator Figures?
I love my local delegation representative, but I'm going to have to go no on this because I think Senator Stutz' bill will take care of it.
That's fine, sir.
Senator Givan? Aye. Senator Orr? Senator Singleton? No. Senator Smitherman? No. Senator Stutz? Aye. Senator Weaver? Senator Barfoot?
Aye.
6-4.
All right, thank you, Representative Hill. Bill's given favorable report.
Thank you. Thank you, Mr. Chairman. Thank you, members.
Thank you. Mr. Chairman Hill, HB 43. We had a public hearing on this last week. We had some good dialogue back and forth. The members will remember that. Just give us again a brief synopsis, if you would, of what your bill does. Remind us of that.
And it basically allows on a Class A felony, a judge to split the sentence, 30 years, split to serve 10, and it is to serve 10 at that point in time. Of course, the individual will be placed on probation for supervised for the period of time that the judge deemed necessary.
Judge, I just want to reference the victim notification. We may want to strengthen some of that in here. I'll work with you on that at a later time. I know you're not opposed to that, and certainly want the victims to have the understanding of what's going on the cases and have the knowledge of what the court's doing and what pardons and parole as well as DOC is doing.
And no question, but the thing about this bill is that it removes from pardons and paroles. This is a sentence that is imposed at the point in time that the individual is sentenced. So it is not a 30-year sentence, get parole when you get it. It is a 30-year sentence split to serve 10 in prison. Okay.
And Judge, I think we made the point last week on a 10-year sentence on a split sentence, that is day for day on a split sentence.
Correct.
Under current law, a 20 split 5, an individual would have to do 5 years under current law on that split unless the judge brought them back during that 5-year sentence. As I understand this bill, that 10-year implementation as a base, the bottom of that, the judge could not re-review them, could not bring them back. So it is truly a day for day on that 10-year sentence. Am I correct?
You know, it precludes the judge from going back and resentencing. Yes, it precludes it.
And as I read the bill, the 10 is a minimum sentence on the split that they could give them.
Yes, sir.
Okay. All right. Members, any questions or comments? Senator Coleman Madison, then Senator Smitherman.
Thank you, Mr. Chairman. This is a legal question. I don't know. If they found new evidence in this particular case, could that be reheard?
I don't know that I know the exact answer to that, but I think there's already a procedure in place, be it a Rule 32, where the courts could address whether or not there was evidence that wasn't submitted or not known at the time. So I think this would apply broadly across the board.
Okay, thank you.
Senator Smitherman.
I move favorable report.
Got a motion for favor by Senator Smitherman. Got a second by Senator Givan. Ms. Ogden, if you'll call the roll for me.
Senator Albritton? Senator Bell? Senator Carnley? Senator Coleman Madison? Senator Elliott? Senator Figures? Senator Givan? Senator Orr? Senator Singleton? Senator Smitherman?
Oh, aye.
Senator Stutz? Senator Weaver? Senator Barfoot?
Aye.
10 to 1.
All right. Thank you, Chairman.
Sir, thank you. I appreciate it very much.
Next up, HB 49, Representative Simpson. Good morning.
Good morning. Thank you, Mr. Chair, members of the committee. I come to you this morning with HB 49, which would add potential to the current capital language to add the potential charges of rape of a child under the age of 12 and sodomy of a child under the age of 12 to the potential punishment of being capital murder.
Correct.
Not capital murder, but capital rape and capital sodomy, which would be eligible for the death penalty.
And correct me if I'm wrong, I think that was amended into the House to make it a broader age range than what you'd originally filed. Is that right?
Correct. It was originally filed under the age of 6. There was a bipartisan amendment that moved it to 12.
And if I remember correctly, looking at that vote count in the House, I think it was somewhere around 99 to nothing or somewhere.
I think it was 93-7. Most of the
Okay.
people that were opposed came and spoke as being opposed to the death penalty in general, not opposed to the bill for the purpose of what it does. As a matter of fact, it was Representative Adeline Clark in Mobile who had requested the move from 6 to 12 at the time.
Understand. Senator Smitherman, I think you had either a question or comment.
I did, but you answered it. So we're changing it to saying basically we're gonna execute. I mean, we're not execute, but we're gonna kill. Give them the death penalty. We're gonna kill somebody. You know, that's what we're saying. It's okay for them to kill them.
Well, there's two. It's not a mandatory sentence. So
I
what would
understand that.
What would happen is they would have to. The prosecutor would have to charge it as capital rape or capital sodomy. At that point, the jury would have to make the determination for guilt, and then at that point, the jury would have to make the determination for death or life without. It's the same as if it is for murder currently. So you have regular murder and you have capital murder. We would continue to have regular rape, and this would be potential for capital rape.
I just have a little concern the fact that, of course, if that took place and the person who was the victim, if they they were murdered, they were died, something like that, then, I kind of get a perception of what you're doing here. But as heinous as that is, okay, and yes, I understand what you were saying about the 99 and 73, because my personal feelings, I feel like the 99. I mean, not that it have to always be, but I got 3 girls, and I leave it right there, So, but I am concerned about the fact that the person who is the victim, if it's not they're not dead.
Correct.
We're getting ready to kill the person who did this, and that, like them 7 people, that's where I have a concern in that aspect. The punishment, from an emotional standpoint, and from how I would feel, the punishment meets the crime. But from a practical purpose, the punishment don't match the crime. I mean, because it's death. If we had said life without parole, well, yeah, it should never be back out here with us. Yeah, I agree with that, But if we're going to kill somebody, and this is a situation, because usually in capital cases, it's where you shot and killed somebody or you murdered somebody. Correct. And then they say, okay, you get the death penalty. But now we're extending the death penalty to personal or crimes that's on a person. And that's a concern that I have, because it doesn't match.
Thank you. Senator Figures.
Thank you, Mr. Chairman. Representative Simpson, you and I have already had a conversation about this. I, too, do not believe in the death penalty. In fact, I did a project on this in college many, many years ago, so I've not
It wasn't that long ago. I'm not going to say that.
I've not believed in the death penalty all of my adult life, so I will have to vote no, but I did want to go on the record as saying, because you know how I feel about our children and about protecting them and the laws that I have sponsored and have passed on their behalf. So I thank you for bringing this with the heart to make sure people pay that penalty for doing such a terrible crime against our children, but I can't vote for the death penalty.
Thank you, Senator Weaver, and
Thank
then
you, Mr.
Senator
Chairman.
Singleton.
Representative Simpson, I'd like to thank you for all that you do to protect our children. At the appropriate time, I'd like to make a motion.
Got a motion for a first, and a second by Senator Orr, Senator Singleton.
Does the age limit makes it a strict liability crime, or are there other elements at that time the judge will look at?
No, it would be a strict, if you have intercourse or sodomy with someone under the age of 12, it's a strict liability.
Okay.
Now, that would be something that the jury could make the determination as to whether or not they impose death or not. But, that's a factor for, it still has all the same defenses if you don't have the mental incapacity for those things. It's the same way as you would. There's no additional defenses through there. It doesn't take those defenses away.
Thank you, Representative Simpson. We got a first and a second. Ms. Ogden, if you'll call the roll for us.
Senator Albritton? Senator Bell? Senator Carnley? Senator Coleman Madison? Senator Elliott? Senator Figures? Senator Givan? Senator Orr? Senator Singleton? Senator Smitherman?
Abstain with reservation.
Senator Stutz? Senator Weaver? Senator Barfoot?
Aye.
7-3-1.
Thank you, Representative Simpson. Bill's given favorable report.
Thank you, members of the committee.
We're going to skip HB 94. I don't think Representative Givan is here. We're going to go to Mr. Chairman, HB 137, Reynolds.
Mr. Chairman, thank you. Committee, as you recall, in 2022, both bodies passed the wire intercept law. It was called the Billy Clark the Third Act after an undercover officer was killed in line of duty. Just as a refresher, this is for felony drug cases only. And I did have the opportunity, myself and Senator Chambliss, to go to SBI. This body put a lot of safeguards in place, including a sunset. And so we went over there to put our eyes on the operations of that intercept. And what we saw was everything we talked about. Double security. You had to badge into an area to get to a locked door to go in and see the server where the information is stored. You went down the hallway, a separated area. You saw 2 workstations. You saw the sign-in we talked about during the evidence sign-in. You saw a log where they signed in, signed out. In other words, if they're listening to an intercept and all of a sudden the guy's attorney calls in, they cut the machine off. and that they had plenty of evidence that was done. So really appreciate the safeguards they put in. And if you don't mind, Mr. Chairman, let me just kind of go through.
Yes, sir.
They've done 4 of these intercepts. They were up after the training and the purchase of equipment, did 4 of them. And just to understand the intensity of these wiretaps, 4,800 hours were invested in just 4 intercepts. 2 of them were extended by the judge. 10 search warrants conducted, 2,500 grams of fentanyl seized, 12,000 grams of cocaine, 100,000 grams of marijuana, 37 firearms seized, 10 vehicles seized, and over 230,000 in cash, and 19 arrests so far. So this bill, HB 137, would ask you to remove the sunset so they can continue this great enforcement. And the second thing is we've run into an issue, SBI has. We need foreign interpreters in the room. One of the safeguards is we said only law enforcement personnel could monitor that, but we need foreign interpreters there to know those sensitive times to say, hey, this is going personal, you got to turn the machine off.
I want to tell you, I'm appreciative of you bringing this. You know, we had some conversations several years ago. There were some folks, and including me, that were concerned about the balancing act of making sure that we protected people's constitutional rights. And everything that I've heard is that has been accomplished. So I'm appreciative of that. Senator Smitherman.
And
then Senator Weaver.
In the requirements to get approval for the taps, does this bill alter or amend the present requirements in order to be able to secure?
No, sir, not at all. I think we had 4 levels, and those 4 levels are still in place.
Okay, so this, what else does this bill do that you just told us it does? You know,
Only removes the sunset, and then it adds for adding foreign interpreters.
Okay, it's not a may change to shell or something like that in here, is it?
No, sir.
You know what I'm talking about?
No, sir.
Because I'm trusting what you're saying, Mr. Chairman.
Well, we trusted and verified, and appreciate SBI letting us come in there and look at it for about 2 hours, and really pleased with the work they're doing.
Okay, thank you, Mr.
Senator Weaver and then Senator Albritton.
I'd like to thank you for bringing this bill. I think it's a great bill, and at the proper time, I'd like to make a motion to approve.
Got a motion for first Senator Albritton.
I would second that motion, but I will, one particular question. You've got the qualified interpreter here for an individual and such. We may, and I'm not making any changes at this point, but we may look at doing something with AI or with digital stuff, because machines can interpret as well or better than humans can. So we might have to put something in on this at some point in the near future to allow that to become the interpretive matter rather than an individual. Just my thoughts.
Certainly something to look at down the road. I'm not sure if we're there yet.
I want to point out 2 things. Number one, thank you for the work that Mr. Harper does for the committee. There's a note on there about a possible technical correction. I'll get with you about that. Changing the term person under 22B 1B14. A different definition of person, but we'll talk through that and at the appropriate time after committee. The other thing I wanted to point out is that Senator Coleman Madison and myself have been working on potential legislation regarding translators, foreign language translators. And so currently under Alabama, I am unaware of any licensure process in which foreign translators or interpreters are licensed. And so we want to make sure that we tighten that up. That has nothing to do specifically with your bill, but we've been working on that process, and hopefully we'll have something that the body can look at here shortly. AOC maintains a list, and there's different levels on that list, and some of them it's easy as if you order a book and a manual and read it, then you get level 1. They don't call it level 1. So, but we want to look at that to make sure that they are truly qualified interpreters and translators. So, just wanted to point that out.
And they would be sworn in. We put some language on page 4 related to that. We talked openly about it. We understand there's an association in Alabama. May try to work with them to get qualified, and then they would have to swear to confidentiality.
Good. We just want to recognize Senator Coleman Madison and the work that she's done on that. On the translator portion of that. So we've got a first and a second. Any other discussion on HB 137? Hearing none. Senator Smitherman? Yeah. Sure.
Repeal of the agency Billy Clarity, the third act. What, I see your last 20-2B-16 provides for the automatic repeal. What are we automatically repealing?
It took out the repealer.
Right in the sunset.
There was a sunset portion when we passed it in 22, definitive time for which it was supposed to go away, and that's part of, I think, what he's trying to accomplish is doing away with that sunset provision that was in there initially from a couple of years ago.
I got you. That's what this is?
Yes, sir.
Okay, thank you. I'm ready.
All right, we got a first and a second. Ms. Ogden, if you'll call the roll for me.
Senator Albritton? Senator Bell? Senator Cornley? Senator Coleman Madison? Senator Elliott? Senator Figures? Senator Givan? Senator Orr? Senator Singleton? Senator Smitherman?
Aye.
Senator Stutz? Senator Weaver? Senator Barfoot?
Aye. Thank you, Mr. Chairman.
Thank
Bills
you, Mr.
given
Chairman.
favorable report.
Thank you, committee.
Next up, Representative Lee. Come on, Mr. Chairman. Tell us about HB 156.
Thank you, Mr. Chairman and committee. Under existing law, an individual may only be arrested on an out-of-state warrant if the individual has been charged with a crime that is punishable by death or life in prison in the other state other than Alabama. This changes gives the law enforcement the ability to arrest, whether it's a death penalty or not. I think this is an old law that we didn't have technology back years ago, and today we're taking advantage of technology and we don't have to have a warrant in hand.
You got a motion for favorable by Senator Givan, second by Senator Weaver. Any discussion on the bill?
Just one
Senator
thing.
Smitherman.
Would this affect a situation where a person has a trying to think of it,
Probably not.
A detainer.
I like you because you always like that. I mean, for as long as I've known you, I was chuckling when I looked at you sitting over there thinking about some of that kind of stuff. But no, you know how someone has a protective order. You know, like you coming out of state, Georgia, one in Georgia. Now that person comes to Alabama. The one, you know, in this case, most of the time it's a woman she's trying to have an order to protect herself. Okay, so this person comes over here in this state. Then if that person, would this a bill allow that woman to call and say, look, it's a protective order. He's over here now and he's violating a protected order.
I'm not an attorney, but I would think not. I have nothing to do with this.
And I ask that because under harassment and a misdemeanor, I guess you could call it assault, that was done on a person who received that in Washington, D.C., but lived in Alabama. That they were under that requirement there, even in Alabama. Okay? That's what the judge said up there, that they were. So I'm asking here, you know, that's why I asked. Because, I mean, I want it to be that way. I want it to be where that woman that comes over here and this guy is on that we can then do that. So, but this bill won't allow us to do that?
That's not my intent for this bill to go to that level. However, someone may can interpret it that it does. That is above my pay grade.
So what's your intent in this bill?
My intent, if someone comes to the state of Alabama, you're just talking about rape and incest, and if there's a warrant out for them in another state, if we don't have a warrant in their hand, we can't arrest them if they come through Dothan, Alabama or Montgomery. Now, if we stop them, we can, if this passes.
You said technology, so does that mean that then they can scan and send us a copy of that warrant?
Well, I'm sure they have the ability to see if there's an outstanding warrant on any person that they stop.
And I think it's probably somewhat outdated, the whole paper copy in your hand anyway, even existing law, and you make that point. Senator Albritton?
Thank you, Mr. Chairman.
Yes, sir.
I've got a concern on this. I understand that we need to have the opportunity to arrest people that are running and such as that. But I can see circumstances where this could become, as you said, misinterpreted or misused. There are warrants that are issued, in particularly in domestic matters, that are issued sometimes without the knowledge of the other party, without evidence of any wrongdoing. It was simply issued because of a claim. And I'm fear that this will become easily abused, and we're gonna wind up with domestic matters, and our police are gonna be tasked with the charge, because once we do this, they are going to have not only the opportunity, but also the obligation to make the arrest. I'd like to have some more parameters on this, some more guidelines of degrees or something, if we can talk about that some.
Let me address that. I mean, the bill calls for felonies. It's punishable by a year or more, so there wouldn't be misdemeanors from other states. But what would be a felony? You could serve that person without having an actual paper copy.
Class D felonies, Class C felonies, anything of that nature. Again, we're relying on hundreds of thousands of different judges in different jurisdictions, even municipalities, where a warrant could be issued. And my concern is how much of validity is there. There needs to be some kind of screening or some kind of protection that comes into play.
Yeah, I don't disagree with you, but under current law, those warrants can still be issued under Alabama state law, whether there's those protections before, whether or not they were valid evidence or complaints.
Maybe we ought to deal with that too.
Well,
Yeah.
Senator Figures.
Thank you, Mr. Chairman. I wanted to ask you, give me a scenario as to how this would work when a police officer stops someone, perhaps for speeding. Then they go back and they check their license and they find that. How will they respond to the driver? And they are about to arrest him because the policeman said that there was a warrant out on them. Are they going to have to show them proof of that, even from a digital standpoint, and not, or will that officer just be able to say, I have a warrant on you, they have a warrant on you, so I have to arrest you? How would that work?
I would think, I'm not a police officer, but I would think they would confirm the person they're talking with is the person that has the warrant.
But it has
and there
to,
would be a
but is it in the
confirmation.
bill?
Ma'am?
I'm very particular about clarity in a bill, so that there's not room for a number of different interpretations, because, you know, different personalities happen, you know, deal with things differently, if you will. So if we pass this out, I'd like to make sure that there's an amendment to make sure that that person is shown the warrant some kind of way. They may not have to have the piece of paper, but okay.
Mr. Chairman.
Definition of reasonable. Right.
Senator-
I may have an amendment, right. Thank you.
Okay.
Thank you,
Senator
Mr. Chairman.
Smitherman, yes, ma'am. Senator Smitherman, do you have another comment or a question?
Well, my colleagues over here, I was what they call it, what the kids call it, y'all, I was ear hustling on my colleagues over here. And they brought out a good point in their conversation, is that there are warrants that stay on the book because of clerical errors of not making interest yeah, I mean, a lot of them. And now we're saying that those people going to be arrested for warrants that they've already had. They go back to what the senator was saying there. There's got to be a heightening of the screening.
Senator Smitherman, I think Senator Orr had a bill that helped with that scenario, because I think you're correct. There are people who are in DOC custody now who have maybe a misdemeanor warrant, for instance, and that puts a hold on them. And when they get released at some point in time, 5-10 years later, then they've got a, you know, either a hold on them from a municipality, or they let them go knowing that there's a hold. Maybe there isn't a hold that DOC knew about, but then they get pulled over later and there's a warrant on there. And it's still an active warrant, maybe a valid warrant. But I think Senator Orr has a bill that cures or helps that issue about those outdated warrants out there.
But let me ask you from a chairman standpoint, you know, not just lawyer standpoint, but a chairman standpoint, is that if if it's my understanding that take this bill, because it's before us. If we pass this bill, and although his bill has that in there, because this is the next bill after that bill, if that touches on these areas different in here, then that is not law anymore. This law is what here is going to trump what this is, because it's filed after established law to amend whatever's out there in the world. Can you answer that for me?
I'm not sure procedurally that that's correct, but aside from that, my understanding of the legislation that he has would talk about stale warrants for it, not just this scenario, right? But other scenarios as well, warrants that have been issued and never been acted upon. So I think that is I think that problem, that legislation he has, at least as I remember it, would cure that, not just for this scenario, but for others as well.
Well, I'll just say to the sponsors that I'm going to vote for it in committee, but I'm locked in with what he's saying. We've got to do some more tightening up.
All right, no further discussion then, Ms. Ogden, if you made a motion, Senator Weaver had the first, Senator Carnley had the second. Ms. Ogden, if you'll call the roll.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Givan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Aye.
Favorable.
Thank you, Mr. Chairman. Appreciate you being here and explaining your bills, be given a favorable report.
Okay, thank you, Chairman and committee members.
Thank you. All right, HB 250, the rock star of the House portion of Sunset.
Last man up.
Last man up.
Is he the last?
We've got an amendment, I think, on HB 250. If you could give us an idea of what your bill does, and then I think Senator Coleman Madison has an amendment she wants to offer.
Yes, sir. I think y'all have already moved something like this in committee already in the Senate, so this is just a companion, which we do a lot, I understand, for each house to move at different rates. This involves statements of economic interest. Currently, we have like a rolling schedule of deadlines depending on the candidate. If you do this, then the deadline to file the economic interest happens after that. This kind of clarifies and kind of makes it solid based on a date that we set as opposed to when the person does what they do on their end. So it kind of makes it more solid and less confusing. We have had people who have missed their deadline because of it.
We've got an amendment. Senator Coleman Madison, you want to explain what that amendment does? Should be in your package.
Amendment. Okay,
Yes,
we looked at candidates, party candidates, but we forgot about municipal governments. They have to file the same thing.
So second move.
Got a first and a second on the amendment. Ms. Ogden, do we have a good roll?
Yes.
Let's use any objection using previous roll. Hearing none, the amendment's approved.
I move it.
Got a motion by Senator Coleman Madison, Senator Smitherman a second, Senator Carnley a third, for favorable on the bill as amended. Any opposition using previous roll? Hearing none, bill's given a favorable report. We've got one last bill in there. Does anybody know if?
Thank you, Chairman.
Thank you for coming. HB 94, Representative Givan. She's not here. Anybody carrying that bill for her? All right. If not, then we'll carry the bill over and we'll try again at a later time. All right. Meeting adjourned. Thank you.